Now, Dan's done a really good video about those Lucy Letby notes in the diary, and the fact they were done by the at the suggestion of the therapist. And a lot of people have asked and said, well, hang on, how were they admissible in the first place? Why didn't the judge exclude them? How did they get to be in evidence? So what I thought I'd do is briefly discuss what we call confessions as a matter of law. What counts as a confession, and what the rules are about admissibility, and then what way it can be put on them. Now, they're all governed, this is all now governed by Section 76 of the Police and Criminal Evidence Act 1984. And I've actually printed that out just so that I can read it to you directly, because, the devil is in the detail on this one. So the Police and Criminal Evidence Act provides that a disputed confession cannot be used in evidence against an accused person unless the prosecution proves beyond reasonable doubt that it was not obtained either by oppression of the person who made it, in other words, oppressing the actual suspect, or in consequences of anything said or done which is likely in the circumstances existing at the time to render unreliable any confession which might be made by him, or presumably her, in consequence thereof. I mean, in the trade, we just talk about threats or inducements. That's like the shorthand for that. But what counts as a confession? Well, and in law, a confession is, or includes, any statement wholly or partly adverse to the person who made it, whether made to a person in authority or not, and whether made in words or otherwise. The issue of whether a statement has been obtained by oppression or in circumstances which make it unreliable is always a question of fact in all the circumstances. Now, it's interesting there, of course, because admissibility is a matter for the judge, and judges are arbiters of law, not fact. But this is actually, a factual test. The judge will look at all the circumstances. So what if you want to challenge a confession going in? How do you do it? Well, we have what we call a voir dire, which is like a mini trial. I mean, what voir dire means is interesting, because the way the Americans use it is very different to how we use it. And there's lots of things about what's the derivation, whether it means to tell the truth or to look at, closely and all, that sort of thing. But a voir dire is like a mini trial. So this takes place in the absence of the jury. Quite often it'll take place as a preliminary issue before the trial even starts, so that each side knows, what the evidence is likely to be. And both sides can call evidence as to the admissibility. So what counts as oppression? Well, oppression obviously includes things like torture or inhuman or degrading treatment or the threats of violence. But the test is it's just given its ordinary dictionary meaning. The exercise of authority or power in a burdensome, harsh or wrongful manner, unjust or cruel treatment of subjects, inferiors, etc., or the imposition of unreasonable or unjust burdens. Now, the mere fact that, the police might yell at you or sort of shout at you, we know you did it, that doesn't usually cross the threshold. It has to be something beyond that. And of course, when you are being interviewed, generally speaking, under PACE, you have the right to have a lawyer there. And a lawyer's job is to make sure that this doesn't happen. They can't sort of suggest what you say or anything like that. They can't take an active part in the interview. I mean, they can whisper to you and sort of say, maybe you don't want to answer that, or exercise your right to silence. But primarily their job is to, just keep an eye on the fairness of the proceedings. And under PACE, all interviews must be tape recorded unless for some reason it's not practical. I mean, sometimes that includes just the tape recorder's not working, in which case the police will make a note and, then you will be asked to agree it and sign it. I mean, before PACE, this was a big problem. We used to have what, verbaling, as we used to call it, where the police would say, yes, they definitely said this, and it's in my notes. And you remember there was lots of scandals about police writing things after the fact. So somebody would sign off on something, or there'd be something in a police notebook, but they'd go back and change it. And they did all this ESDA testing, electrostatic deposition analysis, which could show that, when things were written, or rather, if in terms of times chronology, this was written before that, this was written at a different time than that, so they could go and say these weren't contemporaneous notes because that was written some time after this, and you're saying this was all written while you were in the interview room. So, that's what oppression is. It's your proper, like I say, it's your proper almost sort of brutalising somebody, not merely sort of going, we know you did it, confess. Now, unreliability is an interesting one, because, the rule says that a confession that's unreliable has to be excluded, notwithstanding it may actually be true. But what can make a confession unreliable? It can be just something like, you didn't let people rest, they were too tired, you didn't let them have, refreshments or something like that. Also, we get into inducements. Now, inducements is interesting because unlike the oppression thing, which has to sort of, you really have to show bad faith, inducements can be, you don't have to show bad faith. It's just that if somebody does something that encourages somebody to make a confession. I mean, the classic example is, look, mate, just come clean and you'll be out of here you'll be out of here in an hour. Otherwise you're going to be here all night. That's the sort of thing. I mean, I can give an example. It's an interesting one. I had one where it was, I don't want to go into too many details, but it was basically a driving matter where somebody had confessed to something, and it was very, very clear because we were able to, I mean, this person had sort of psychological issues anyway, but basically he'd driven somewhere and his girlfriend who couldn't drive was out in the police station, and they said, look, we're going to have to kick your girlfriend out now. And he said, well, she's got no money, can I give her the money? No. How's she going to get home? Not our problem. And they were a very long way from home, so she couldn't stay. It was basically she's going to be turfed out. And he literally, this is the trouble. This is, trouble for the police was it's all on tape. This, and it's like, okay, yeah, I did. I confess. Well, what to? Well, whatever you say. What is it I'm meant to have done? And he did all that. And actually, interestingly, we got that excluded. Mind you, then I asked the prosecution asked the psychiatrist and said, bearing in mind all these cognitive difficulties, should this guy be driving anyway? And he said, oh no, certainly not. So then the DVLA took his licence off him. But anything that sort of implies that you'll be better off if you confess. I mean, just saying things like, look, you'll feel a lot better if you get this off your chest, mate, or that sort of thing probably doesn't cross the line. But that's section 76. That's specifically about confessions. But we also have section 78 of PACE, and that's just unfairness generally, and that applies to any type of evidence. I mean, in America they have that fruit of the poison tree rule, where if evidence is obtained unlawfully or illegally, then any evidence flowing from that is also inadmissible. We don't actually have that here. Although, if a confession is excluded, you can't refer back to the confession. But say, for instance, you torture somebody into saying, where's the evidence? Where have you buried the body? Or something like that. And then you find the evidence as a result of that. Then you can't put the confession in, but you can sort of say, we attended some premises and we found all this incriminated evidence with his fingerprints on it. You just can't say how you knew where to find it. Now, all our American friends were going, oh, well, that's very different over there. The section 78, I mean, it is drafted in very, very broad terms. Now, the thing to remember also is section 78 is not there to punish the prosecuting authorities or the police for bad behaviour. Sort of like, you did something so reprehensible, we're not going to allow this evidence to go in, because, there's justice to the victims as well. So, it's unfair on them. So it only counts if it's something that it's so egregious that your average person would say, well, this just makes the proceedings unfair generally. And that, it is a very, very sort of high burden. But, you just look at everything in the whole. We also have this idea that evidence should be excluded if it is more prejudicial than probative. So what is that? I mean, it's rather weird. So, what's the test for admissibility in English law? It's rather weird. It says evidence is admissible if it is A, relevant, and B, admissible. So relevant, obviously, it's got to go to an issue in the trial. But then it says it's admissible if it's admissible. And what really that means is it's admissible if there aren't any other grounds for excluding it. So if it doesn't breach section 76 of PACE, or doesn't breach section 78 of PACE, or isn't more prejudicial than probative. I mean, more prejudicial than probative is something where, well, yes, because by definition they want to put evidence in that is prejudicial, that assists the prosecution and undermines the defence. I mean, technically the definition of prejudicial is it's before a trial or a hearing, prejudicial, but we use it in that sense as well. So obviously, it's got to have some bearing on the trial, but the idea is, well, actually, yes, it does have some probative value. It is evidence that a jury could properly take into account, or a magistrate could take into account. But the background circumstances are such that there is a danger that it'll just make them go, oh, well, we just don't like this person anyway. I mean, certain types of bad character evidence, for instance, this person once did this horrible, terrible, terrible crime that isn't actually related to the current offence, but we want to put this in to show that he's a criminal and you should be wary about him giving evidence, because by definition criminals are more dishonest. Do you remember I did my video on bad character evidence with Dan? In that particular case, they might say, well, yeah, realistically, does sort of saying, take what he says with a pinch of salt because he's got previous. The fact that somebody's going to go, well, hang on, he did this horrible, horrible crime, and he's clearly a bad person anyway, so we'd better convict him just to keep him off the streets. That is sort of the test. So what about Lucy Letby? Well, first of all, people might be saying, well, hang on, aren't medical notes confidential? Well, actually, no. In English law, the only material that is privileged in the sense that the court isn't allowed to look at it are client-lawyer communications. That's the only evidence, that's the only relationship where the communications aren't admissible. And there are certain exceptions to that, like, for instance, if it's communications in furtherance of a crime, or it's communications that isn't actually, in contemplation of the litigation, whether that's criminal or civil. But if it's sort of genuine lawyers and their clients talking to each other about the trial, then generally speaking that's inadmissible. But everything else, doctor-client stuff, that's not privileged. Priest, stuff in the confessional. Now, a priest obviously might say, well, I'm not going to disclose the secrets of the confessional, but as a matter of law, a priest could be summoned to give evidence and could be told, you have to tell us what happened in there or you're in contempt of court. I mean, that rarely happens, but it could theoretically happen. There's also this thing where spouses supposedly, can't give evidence against each other. Because the idea is that it would wreck marriages if you could. So spouses are, they're permissible witnesses, but they're not compellable witnesses. So if your spouse wants to give evidence against you, they can, but they can't be forced to give evidence against you. People in the comments and more up-to-date law students, because every time I speak about something like this, somebody in the comments goes, "Ow, that was repealed last week." So just check that. But yeah, with the Lucy Letby stuff, so I mean, part of the problem was the police found the notes anyway when they searched her premises. So they found those. So even if they were recording like doctor-client stuff or therapist-client stuff, even if they were confidential, the fact that they found her record of it would waive that anyway. But as I say, it isn't. So, the police could have actually gone, say, for instance, the therapist had made notes of what she said. Theoretically, the police could call the therapist as a witness and say, what's all this about? I mean, this is a big problem for witnesses generally, because you get this in certain, SUL offending cases and, R-word cases, where victims have been sort of advised, don't go to therapy, don't have trauma counselling, because anything you say in there, the defence could actually ask to see the therapist's notes or your doctor's notes and go through it. And, if it was something, and just troll through it to see if there's anything that might assist the defence. I mean, there is a move to make those notes confidential. It's the same thing like, victims have to hand over their phones and have to give access to all their sort of social media stuff, even the private stuff, if they've been texting their friends or WhatsApping their friends. Just so that the defence can look through and sort of go, the next day she never mentioned that this happened, or she was chatting about going out with their friends and she seemed perfectly happy afterwards, so clearly it can't have been all that traumatic for her. That's another issue, and there are a lot of people saying that that should not be allowed. Digital short skirting, they call it, because the old sort of, well, why are you wearing a short skirt if you weren't asking for it? And it's the idea is it's pretty much the same thing, saying that you are not behaving appropriately. I suppose that brings us back to the Letby thing, that people are looking and saying, well, looking at her demeanour and psychology. I'm very cautious of demeanour, because although demeanour is permissible, you're allowed to take into account demeanour. both as judges and juries when assessing sort of credibility and guilt, I think it is very dangerous because, first of all, not everybody behaves in, you know, the same way. I mean, there are cultural issues, and sometimes judges are warned about that, you know, because there's this thing like, there is a tendency to say honest people will look you in the eye and look you in the face, and like being evasive and looking away is a sign of guilt. But in a lot of cultures, averting your gaze is a sign of respect, especially with authority figures. So, and you know, if you see, you know, the prosecuting lawyer as an authority figure or the judge as an authority figure, for some cultures, you know, you will avert your gaze and not look them in the face because it's considered to be sort of rude and inappropriate. And judges are specifically warned about that. And I'm also thinking about the Lindy Chamberlain case in Australia, you know, the dingoes ate my baby one. I mean, effectively, she was convicted because she didn't behave as you would expect a grieving parent to behave. And, you know, there's been things people saying, oh, well, she was on the spectrum a little bit, or she had a particular religious background that made her very stoic about these sorts of things. So judges are warned that demeanour is something that, while they can take into account, be very, very careful that just because somebody has, quotes, absence of appropriate effect, it doesn't necessarily, like, take you anywhere. So yeah, it'd be interesting to see. I mean, Letby now has new lawyers, and I know of the barrister she's instructed, and he's a very passionate campaigner on cases like this. You know, there's another case that he's spoken about, so he is very, you know, on board with this idea of medical staff being convicted of things, and, you know, is it all just the statistical evidence? Is there actually any real evidence? So apparently now she's sacked her own lawyers and instructed him. His only route now is to go to the Criminal Cases Review Commission because, you know, she's had her appeals knocked back. But it'd be interesting to see what he can formulate. I mean, the big problem is that, you know, the defence, it was a very long trial, and the defence had lots of opportunity to put the defence they want, to call the witnesses they want, to take whatever tactic they wanted. You know, they could have raised this issue about the notes. Now, my understanding is, and I have not looked through all the transcripts, I've not even seen them, but people who have been following the trial have said, actually, they didn't spend that much time on the notes. I mean, the prosecution said, here's some notes, here's what you say, why did you say this? And she's saying, well, I was just a bit depressed and, you know, my mind was all over the place, but, you know, I didn't mean anything by it. And apparently they're saying it didn't actually take that much time up in the trial. So, you know, if he was to go to the CCRC and say, you know, find some argument as to, even if he could say these notes are unreliable as admissions, oops, somebody's trying to ring me, I'll just get rid of them. You know, these are unreliable as admissions. It might be that the CCRC or even the Court of Appeal, if they get that far, say, well, yeah, but look, this is only one tiny bit of evidence in, so, you know, a very, very long trial. Because, you know, the test for sort of your second appeals and things is, you know, sort of new evidence. And it's not that it might, if the jury had heard it, they might have come to a different decision. It's pretty much if the jury had heard it, you know, they would have come to a different decision. So it's a very high hurdle. I mean, the other thing that people might ask is, can she appeal on the basis of, you know, negligent representation? And again, that's a very high hurdle. And just because a defence team take a particular strategy and it doesn't necessarily work, you know, that doesn't necessarily mean it's negligent. I mean, it's very hard defending and prosecuting a trial because you have to, even though you plan it, you have to think a little bit on your feet. You know, there are contingencies, there are emergencies. You have to make decisions as to, is this a best approach to do? Is this something we should do? So it's a very high sort of hurdle. Another thing to be very careful of if you ever appeal on the grounds of negligent representation is that you waive privilege. So all your conversations with your lawyers, the lawyers can put that in. I mean, a friend was once, a barrister friend, he was once up where somebody was appealing on the grounds of negligent representation, and he was very, very good about, well, we took a tactical decision not to call this particular witness, because the guy said, if you'd have called this witness, you know, she would have alibied me and all this sort of thing. And he was all very neutral and said, we took a tactical decision that, you know, perhaps she wasn't the most reliable witness, or there were some issues that might have arisen in cross-examination that would have undermined our case. But when the solicitor went in, he just basically said, we didn't call her because we thought he's probably lent on her to give this evidence, and she probably knew that he'd previously murdered his ex-wife. Oh, by the way, people don't know about that. And they just dobbed him in for another murder. So, that's one thing. I mean, I'm not suggesting that there's anything that, she's confessed to her lawyers, because of course, had she done that, how they ran the trial would have been very difficult, very different. Because, we always say, how can you represent somebody if you know they're guilty? Well, you still can do it, because you can put the prosecution to proof and test the evidence, but what you can't do is run a positive, my client didn't do it case. So to give an example, if ID's an issue, you can say, if your client said, yeah, I did it, and somebody says, well, I saw your client do it, you can say, yes, well, what's your eyesight like? How far away were you? What were the lighting conditions? Were you wearing your glasses? Was it raining? Did a bus drive in front of you? So you can actually suggest that the identification is unreliable, but what you can't do is cross the extra step, which you would be able to do if your client hadn't admitted it, and say, well, I suggest it wasn't my client that you saw. So, that's where it is. But I didn't see any, I mean, they ran a positive case of, our client is innocent. So, I don't think there's going to be any sort of, private or confidential admissions in the background to bring us back to admissions, which is where we started. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. And I hope it's addressed some of the questions, because like I say, I saw somebody in one comment saying, the judge should have used Section 76 to tell the jury to disregard the confession. Well, no, because Section 76 is whether the confession goes in or not in the first place. But once it's in, what weight, if any, to put on that is entirely a matter for the jury. The judge can't say, you should disregard this confession, because if you didn't think it should have gone in, it shouldn't have gone in the first place. So, remember that's the threshold. But once evidence is admitted, it's entirely a matter for the jury what weight they do put on that. And judges specifically tell juries, they say, if it appears, you are the arbiters of fact, if it appears at any stage in my summing up that I am expressing a view, you must ignore it unless it's one you already agree with. So if I sound like I'm supporting a piece of evidence and you disagree, then you must, you disagree with it. If you find I'm dismissing a piece of evidence that you think is important, you must, you treat it as important. It's entirely your decision. Lawyers are very key. Now the procedure actually quite often is that judges will discuss their proposed summing up with the prosecution and defence. The judge doesn't have to go along with everything the prosecution and defence say, because you might say, well, we think you should say this, and the judge say, well, no, I'm doing this. And remember that a lot of this now, it's all in this judicial bench book, or the compendium as they call it now. There are standard directions on the law that the judges give. The rather weird thing is they do give a sort of summary of the evidence, which I can understand on a long trial, but you used to get this rather weird thing. You'd have really quick, short trials, and the judge's summing up of the evidence would be longer than the actual evidence was in the trial. So I can see why a lot of the time now they don't bother with that. That's the thing to remember, that once the judge has let the evidence in, what weight to put on that evidence is entirely a matter for the jury. And one thing appeal courts generally won't do is interfere with the decisions of juries. So unless they can actually point and say the judge got the law wrong in his summing up, or the summing up was so prejudicial that it went beyond sort of what a judge is allowed to do, it's going to be very difficult. So yeah, I think Mark's going to have his work cut out here. But obviously, we'll follow this story, and we'll keep you informed. And if anybody has any sort of follow-up comments or queries, stick them in the comments and I'll do my best to address them.